Welcome, class, to Constitutional Law 475. Today we are going over sex discrimination, and my daughter Natalie will be the class participation. But when I ask her questions, they're questions to you as well. So feel free to regard them as questions to you as well. Okay, so Natalie, you have been in a number of my lectures now.
I have.
Right?
And I asked for payment in jelly beans, but...
Yeah, okay. When someone says I'm being discriminated against,
yes,
and they file a lawsuit, right?
Yeah.
Basically, what constitutional argument are they making?
The 14th Amendment.
Outstanding.
Yeah.
I'm very good. What part of the 14th Amendment?
The Equal Protection Clause.
The Equal Protection Clause. Exactly. They're being denied the equal protection of the laws. Outstanding.
Thank you.
Wow. Just made my day, Natalie. Okay, so when was the 14th Amendment passed? I don't need a particular year exactly. Just tell me about when.
It was one of the Civil War amendments.
Excellent. So the 13th, 14th, and 15th Amendments are often called the Civil War Amendments, and they were passed shortly after the Civil War ended, right? So you're looking late 1860s-ish, right? For 13th, 14th, 15th Amendments, that ballpark. Okay. So, the first case that we're going... Well, no. So one more thing. So, when the 14th Amendment was passed,
yes,
was it intended to grant racial equality or sexual equality?
racial equality.
Racial equality, exactly. Were there all kinds of state laws that distinguished on the basis of sex?
Yes, there were.
Yes, there were. That discriminated on the basis of sex?
Yes.
Yes, there were. Right? And so the question kind of became, would the Equal Protection Clause apply at that time to sex discrimination? Right?
Yep.
In Bradwell versus Illinois, which was decided in 1873.
Okay.
So is this really soon after the 14th Amendment was passed?
Yes.
Yes. In Bradwell versus Illinois, 1873, the court upheld a decision by the Illinois Supreme Court denying Myra Bradwell a license to practice law solely because of her sex.
No good.
Okay, right. So, was she being disadvantaged?
She was.
She was. So why would the state have such a practice? Women cannot have a license to practice law in this state.
Because they believe that they were not capable.
Yeah. Frame it more broadly, like we talked about before. What powers does a state have?
Oh, police powers.
Police powers, exactly. So, was denying women the right to practice law, was that seen as a legitimate exercise of the state's police powers at the time?
At the time, apparently.
At the time, absolutely, right? They thought they were protecting the health, safety, and welfare of their citizens. They were making their citizens and their state a better place, right?
Yep.
So, in a concurring opinion, these words appeared. These are a gem, which kind of gives you a feel for the thinking of the time.
Yeah.
The natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life.
Boo.
Natural and proper timidity and delicacy. Then it went on to say, this condition was the product of divine ordinance. Yeah, and so...
Go around saying stuff like that.
Yeah, well, that's the Supreme Court in 1873. So, according to the Supreme Court, were women, in 1873, were women naturally different from men?
Yes.
Yes. Who made them that way?
The Lord.
Well, God. Yeah, exactly. Is the product of divine ordinance. God wanted it that way. I don't know. Who has a more dominant personality? Your Aunt Cheryl or me? Yeah.
Cheryl.
Okay, yeah.
I've never met Cheryl, but Cheryl.
Yeah, exactly, right. So, timidity and delicacy, I don't know. If our family has to go into a battle with an insurance company or something, we're sending Cheryl. So, yeah. But anyway, at the time, that's the way it was seen. So, the point is, at the time, was the Equal Protection Clause being applied to women?
No.
No, it wasn't.
Because we're too timid for that.
Well, yeah. So, denial of voting was upheld. Remember, that changed with the 19th Amendment.
Yep.
It had a ways to go. Didn't get that until much later. Maximum work hour laws that covered only women were upheld. Now, what would be the state interest there? Maximum work hour law that covered only women. Women can only work, whatever it is, 30 hours a week.
Child care?
Absolutely. They felt to have a safe society, a properly functioning society, women need to be home to raise the children.
What if I'm a single parent?
Well, yeah.
Filing a lawsuit.
Yeah.
Dorfler versus Ohio.
Yeah. Bring it on. Also, laws that banned women from certain occupations were upheld. So women couldn't work in certain environments. Like I saw with the law license. She couldn't get a law license. But there were other occupations. For example, you couldn't be a bartender unless you were a member of the bar owner's immediate family. Right? Because again...
So I couldn't start my own bar?
Well, not back in the 1800s. Right? But if I owned a bar, you could be a barmaid. You could...
Wow.
Yeah, isn't that great?
Yeah.
You could if I owned a bar, but there it was. So, the point is, there were a lot of state laws and employment practices that treated men and women differently.
Yeah.
Right? Okay. Then, Congress was kind of the first to start guaranteeing sexual equality. The Equal Pay Act of 1963 guaranteed equal pay for equal work, right?
Yes.
So, if you have two people, one's male, another's female, they're similarly qualified, they're performing a similar job, do they need to be paid the same amount?
Yes.
Yes.
They do. I demand
They
my
do.
payment.
According to the Equal Pay Act. Yep. Then the Civil Rights Act of 1964 forbids discrimination in employment on the basis of sex. Right?
Yes.
Okay. So you had those two acts of Congress. But the real change came with Ruth Bader Ginsburg's orchestrated attack on laws that discriminated on the basis of sex, right? So Ruth Bader Ginsburg has been called the Thurgood Marshall of gender discrimination law, right? And the first case, kind of that signaled things are about to change, was Reed versus Reed. And it was decided in 1971. All right? Okay, so Reed versus Reed, what do we have here?
We had a kid of Reed versus Reed. They were a divorced couple.
Mm-hmm.
And he died with an estate but had no will. The estate was worth like $1,000.
Yep, less than $1,000.
Yeah. And was this Ohio?
Idaho.
Idaho had a law that if a person died without a will, which is a fancy term called
intestate.
Yeah. They died intestate, then there was a certain hierarchy of who the estate or control of the estate went to. And first it was spouse. He was 16, didn't have a spouse. And then it goes to kids. Who was 16, didn't have kids. And then it goes to parents, or other immediate family.
Mm-hmm.
And in that case, it would go to the male over the female.
Exactly. Excellent. So, it goes down those priority relationships. And according to state law, once it reaches a certain priority relationship, if there are two parties that want to handle the estate, then the male is automatically preferred to the female, right? Kind of by all accounts, Sally Reed was much more competent, much more able to handle the estate than her divorced husband, Cecil Reed.
Cecil.
Yeah, Cecil. But under Idaho law, he was automatically put in charge of the estate. So she filed a lawsuit. The case went to the Supreme Court. And, again, one of the whole reasons why this case is so huge is before this case, the Supreme Court had largely just been deferring to the states and saying, well, if you treat men and women differently, that's seen as a legitimate exercise of a state's police powers, right? But in this case, they hauled the state of Idaho in front of the Supreme Court, and they said, state of Idaho, why do you have this law that treats men and women differently? And if you're an attorney for the state of Idaho,
yeah,
what arguments do you try to make?
The males have more experience in the financial aspects of handling the estate.
Yeah.
More qualified.
Yeah, so let's stop right there. So, is there statistical evidence at the time, 1971, to show that more men than women had jobs and were involved in the business world?
Yes.
And consequently handled financial affairs more?
Yes.
Yes. But is it the case that every man has more financial experience and business acumen than their spouse?
No.
No, right? So the court said that's an offensive sex-based assumption or sex-based stereotype, and you can't make state laws based on offensive sex-based stereotypes. There are plenty of women who are more financially savvy than men, who have more business experience than men, so that argument is not going to cut it. So, give us another argument. Try again.
I do not know.
That's just the way it's always been.
Oh.
Right?
That's just the way it's always been.
it's
never,
19... Yeah.
Never a good argument.
Well, the thing is, in this case, it's worth a shot, right?
Yeah.
Because, again, in all honesty, the Equal Protection Clause was intended to try to achieve racial equality, not necessarily sexual equality, right? So the argument, well, that's just the way it's always been, isn't that bad of an argument, but who interprets the Constitution?
The
Supreme Court, right? And so they say, well, that's just the way it's always been, isn't gonna cut it. Even applying our lowest level of scrutiny, which the court did in this case, you still need to show us that you're trying to achieve a legitimate government objective, legitimate or valid. And so what's the legitimate government objective?
There isn't one.
There isn't one, exactly, right? The next argument the government tried to make, the state of Idaho tried to make, was we're doing this out of administrative ease, right? If somebody dies intestate, is their estate usually worth a lot of money, or they probably don't have a whole lot of money?
They probably don't have a whole lot of money.
Probably don't have a whole lot of money. That's why they didn't get around to getting a will taken care of, right?
Like if I die, I give you guys like $60 that's in my piggy bank.
Yeah. What are we gonna do with it all?
The possibilities are overwhelming.
You know, the crazy thing though is, we have a fair amount of assets, and your mom and I didn't get around to writing our will till last year. I was just lazy, I guess, when it came to that financial stuff. That and optimistic I'd stay alive, so. But anyway, the court said administrative ease isn't going to cut it. True, a lot of the time these estates aren't worth a lot of money, but that doesn't justify automatically preferring men to women. That doesn't justify having a law that treats men and women differently. So if both a man and a woman want to handle the estate, you, as a state, the state of Idaho, you must hold an administrative hearing to decide who's best able to handle the estate.
Oh, but I don't want to.
I know you don't, state of Idaho. It'd be easier just to have a state law that puts men automatically in charge, right? But you're gonna have to hold an administrative hearing to decide who's best able to have the estate. Will that impose some costs upon the state of Idaho?
Yes.
Yes.
I don't have the money.
Yeah, I don't know. So Idaho is probably not happy about it.
I'm not.
It's going to cost them a little money, but at the same time, it establishes the precedent. The court is no longer turning a blind eye to state laws and practices that treat men and women differently.
So you better get around to change it.
Yeah, well, exactly. And so it served notice to the states, we're not just going to turn a blind eye anymore to this.
Woohoo!
Right? Yep. Okay. Now, any question on that one?
No.
Okay. So, just so we're 100% clear in terms of the court's Equal Protection Clause jurisprudence and how it has evolved, the court in that case, Reed versus Reed, was able to strike down the state law using just the rational basis test, its lowest level of scrutiny. The state could not even provide a legitimate government objective, right? Administrative ease isn't cutting it. The fact that men are more involved in the business world, that's a sex-based offensive stereotype, offensive assumption. There are plenty of women who are capable of handling financial matters. So the court said, your arguments aren't cutting it. Any question? It does. It makes a lot of sense. Okay. Now that takes us to, and so the point is they struck it down using the lowest level of scrutiny, which means the state arguments stink. Right? Yeah. Exactly. And they don't even have to apply a higher level of scrutiny. This takes us to Frontiero versus Richardson,
Frontiera.
which was decided in 1973. And before we get started, Reed versus Reed dealt with an Idaho state law.
Yes.
Frontiero versus Richardson will deal with a U.S. military policy, right?
Yes.
Does the court have a history of deferring to the military?
Yes.
Yes. So Frontiero had her work cut out for her here because the court has a history of deferring to the military. So Sharon Frontiero was a lieutenant in the U.S. Air Force, and her husband was a full-time student receiving veterans benefits, right?
Yep.
So under kind of military policy at the time, in order to receive benefits for a spouse, a female officer had to prove that her spouse was financially dependent upon her.
Yes.
Received a certain percentage of his financial support from her, right?
Yep.
If you were a male officer in the military, then your wife's financial dependence was assumed, and your spouse automatically qualified for a number of benefits. Right?
That's unfair.
Right. So who's disadvantaged in this situation? Female officers or male officers?
Female officers.
Female officers. Now, in 1973, how many female officers do you think there were in the military?
Not many.
Not many, but Sharon Frontiero was one of them, right? And she said, this is an unfair policy. So, case went to the Supreme Court. And the Supreme Court asked the military, why do you have this policy? And what do you suppose the military answered?
Well, first of all, we don't have that many female officers.
Right.
Next.
So it's no big deal.
Yeah.
Right.
Next. I forgot.
Administrative ease.
Administrative ease. Oh, that's what they always follow.
That's right. Administrative ease is just easier to assume that every male officer's wife is financially dependent upon him. Now, if that's your argument, I've always thought this was a silly argument, because if administrative ease is your argument, then what's easier than just making all spouses eligible for benefits?
Yep.
Right? So I don't understand why you'd single out female officers and say you have to prove that your spouse is financially dependent upon you, but male officers will assume your spouse is financially dependent upon you, and then make the argument of administrative ease. To me, that's just a bad argument.
Yeah.
The easiest thing is just make all spouses eligible for benefits.
Yes.
Anyway. Next, is the policy, in all honesty, based on offensive, sex-based stereotypes and assumptions?
It is.
It is. It assumes that every male officer's wife will be financially dependent upon them. Oh, when you get home, honey, I'll make sure to have dinner ready.
And apple pie.
And apple pie would be nice. and it assumes every female officer will have a male spouse who is out being a breadwinner also, and consequently doesn't need benefits, right? Yeah. So, I mean, it's just offensive. Is it possible that some husbands of female officers just want to stay home and raise the kids?
Very possible.
Very possible. I think that'd be kind of cool. Maybe for a while.
Yeah.
So the court again condemned the imposition of sex classification for administrative convenience, as well as the practice of incorporating overly broad sex-based assumptions into the law. All right? Okay, now, the court, in this case, started to show some divisions on what test should be applied. Yeah. The rational basis test or some higher level of scrutiny. Right? So, Justice Brennan's opinion defended the use of strict scrutiny. But only 3 of his colleagues supported him. Douglas, Marshall, and White. Right?
You need at least one.
Right, exactly. So, they agreed the policy was unconstitutional, but there's disagreement here on which test should be applied. Just like in Griswold versus Connecticut, there was disagreement about where your right to privacy is found. Right?
Yep.
Okay. So, Blackman, Berger, and Powell concurred in the judgment, but explicitly opposed the application of the strict scrutiny test. Mm. So they said, strict scrutiny, we reserve that for race, and other situations like race. There are differences between men and women. Uh-huh. So we're not going the strict scrutiny route. Yeah. Rehnquist dissented in the case. Yeah, well, Rehnquist, why are you woo-hoo?
I don't know, I just say
okay. Rehnquist dissented. Again, he's one of those that has a history of deferring to the military.
Oh, he's one of those people.
Yeah, very much so. He has a history of deferring to the military. He doesn't want to touch military stuff. If it's a military policy, I'm going to assume it's valid.
That's not the wisest thing.
Right. And in one line, Potter Stewart found the regulation unconstitutional without saying what standard he applied. So that's classic Potter Stewart. Remember, he's the one in the obscenity cases who finally said, I'm not going to try to define it again, but I know it when I see it.
Oh, yeah.
Yeah.
He's interesting.
He is interesting. And some scholars have commented on the fact that Stewart is interesting, right? Yeah. There are some times when, in some cases, I really agree with him.
Yeah.
Right? Braunfeld versus Brown, the Blue Laws case, right?
Yeah.
Is one of those cases. Do you remember that one, or have I told you that one?
I don't think so.
That was a Sunday closing law, right? Oh. Required businesses to close on Sunday.
Well, that's unfair.
Right. If you're not a Sunday Sabbatarian,
well,
right?
Yeah, don't,
right.
Jews is like Saturday.
Jews, absolutely. Yep, so Abraham Braunfeld, he was an Orthodox Jew, he was Jewish.
Yeah.
Saturday was his Sabbath.
Mm-hmm.
He was forced to close on Saturday because of his religious beliefs, forced to close on Sunday because of the state law.
Yeah.
And the Supreme Court upheld that state law. But Potter Stewart dissented, and he said, this law forces a man to choose between observance to his religious beliefs and his economic survival.
Yeah.
That's a cruel choice, and one that can't be swept under the rug and forgotten in the name of enforced Sunday togetherness.
Yeah.
Right? Yeah, so Potter Stewart was capable of some interesting views at time, right? and yeah, so in one line, Stewart said this regulation is unconstitutional, but he didn't say what standard he applied. Just, it's unconstitutional.
Yeah.
Yeah. Okay, now that takes us to Craig versus Boren, 1976. And this case is huge for a couple of reasons. Number one, it's going to take us to a new level of scrutiny. What's going to be called heightened scrutiny or intermediate scrutiny that we talked about before. And it's also going to strike down a law which disadvantages men. Right? So, it's huge in both regards. So, in 1972, Oklahoma passed a statute setting the age of legal majority for both males and females at 18. Right?
Yep.
There was one exception. Males could not purchase beer, even with the low 3.2% alcohol level, until they reached 21. Females could buy beer at 18.
Unfair.
Okay. Well, the state differentiated between the sexes in response to statistical evidence indicating a much greater tendency for males ages 18 to 21 to be involved in alcohol-related traffic accidents, including fatalities. Okay. So Curtis Craig was a 20-year-old male who wanted to buy beer, and Carolyn Whitner was a licensed vendor who wanted to sell it. They brought suit in a federal court. So the case went to the Supreme Court, and the Supreme Court asked the state of Oklahoma, this law does not look okay. Okay. Oklahoma, why do you have this state law? If you're the state of Oklahoma, you cite the statistical evidence, right?
Yes. I say 0.1% of females are in charge of intoxicated driving accidents, and 2% of males.
Okay. Yeah, so it's 2% of males were arrested for DUIs or DWIs, and 0.18% of females. 0.18% of females were arrested for DUIs or DWIs, whatever they are in Oklahoma. So is that a statistical difference?
It is.
It is. But if you're the state of Oklahoma and your objective is to keep people safe,
yes.
Are there probably better ways of protecting people from alcohol-related traffic fatalities than a policy that allows women to buy beer at 18, but guys have to wait to 21?
Yeah, there are probably better ways.
Probably better ways, exactly, right? Yeah. If you look at gender, 2% of guys get DWIs. Is there a very loose fit between gender and who gets DUIs?
Yes.
Yes. Only 2%.
Yeah.
Right? So in other words, is gender a very good predictor of who will drive drunk?
No.
No, it's a terrible predictor of who will drive drunk. Again, difference between men and women is statistically significant, but that does not mean that gender is a good proxy for who's going to drive drunk. Or in other words, it's not a very good predictor of who is going to drive drunk, right?
Yep.
So the court in this case said, we're going to up our level of scrutiny.
Yep.
We're going to go to what's called intermediate scrutiny or heightened scrutiny. It should be on your charts. I showed you the other day, right? And they're going to ask, is the policy a substantially related means of accomplishing an important government objective? Okay, so safety. Is that an important government objective?
Indeed,
yes.
It is.
As a matter of fact, it's a compelling government objective. Exactly. So the law passes constitutional muster in that way. But you also have to look at the means employed, right? Guys can't purchase alcohol until they're 21. Women can purchase it when they're 18. Is that a substantially related means of accomplishing an important government objective?
No.
No, it's not substantially related, right? If you really want to keep people safe, what's a gender-neutral way of doing that?
Just make everyone
wait till they're 21. Absolutely, right? And so the majority said, kind of in a way, this law is a farce. All an 18-year-old male has to do is get a... I'm sorry, all like a 19-year-old male has to do is get an 18-year-old girlfriend to buy it for him.
Yeah.
And they're like, what a joke. So they said this is not a substantially related means of accomplishing an important government objective, which is heightened scrutiny, and that's what the court's going to apply in sex discrimination cases from here on out. Now, Rehnquist dissented.
Rehnquist.
I know. Keep in mind, this is when he was still young. He's dissenting in Froniero versus Richardson. He's dissenting in this one. Why do you think he dissented?
I don't know. I'm not him.
Okay, well, again, you haven't been with us all semester, Natalie, but Rehnquist has a history of deferring to the state.
Oh, yeah.
Right? And
military.
So... What?
I said and the military.
And the military, absolutely.
Why is he even on the court then?
Well, just when laws are clearly unconstitutional, right? So the first thing he asks is, what fundamental right are we defending here?
There isn't one.
Well, there isn't one, exactly.
My right to buy alcohol.
To purchase beer, exactly. And he's all, it's not even the right to consume it. We're just talking about the right to purchase it. And, so give me a break, right, is kind of his argument. It's like, it's the legitimate exercise of the state's police powers. If they think it makes sense, let them do it. The next argument he makes is there is no suggestion in the court's opinion that males in this age group are in any way peculiarly disadvantaged, subject to systematic discriminatory treatment, or otherwise in need of special solicitude from the courts. So, according to the court's own words, do they have a special responsibility to protect discrete and insular minorities?
They do.
They do. And so Rehnquist said, males are not a vulnerable population. If they don't like the law, they should go to their state legislature, which is probably overwhelmingly male, and get it changed, right? That was his argument, which is an interesting argument. But the majority disagreed, and they said, when laws treat men and women differently, they're going to be subject to heightened scrutiny, regardless of which gender is disadvantaged.
Makes sense.
Does it make sense?
Yeah.
Okay. So is that a big victory for women's rights advocates?
Yeah.
Why?
Because it solidifies the way that they're going to treat both genders, so they can't just discriminate against them.
Right. Well, in a way, yeah.
Okay. Fine.
Basically, what the court is saying is we're going to subject all laws that treat men and women differently to heightened scrutiny. And so that in the long run is going to work to the advantage of women.
Yeah.
Right? So even though this one particular law may have disadvantaged men, it's going to be much better for women in the long run to have all laws that distinguish between men and women subject to heightened scrutiny.
Yeah.
Yeah. Exactly. Okay. Now, that takes us to Mississippi University for Women versus Hogan, 1982. Okay, so Mississippi University for Women, private or public school?
Private.
Public.
What?
Yeah, public.
How? That's just for women.
Well, exactly. That's 1982. So we'll get to that point in a minute. So it was a public school. It was just for women. Now, are private schools allowed to be single sex?
Yeah.
Yeah, absolutely.
That's why
They're
they
private.
send you off to boarding school.
Yeah, exactly. So this lawsuit was filed by a male who was denied admission to a nursing program. And it challenged state-operated single-sex schools. State-operated single-sex schools. Okay? Now, although the state expanded the choices and opportunities for females by creating a women's college, critics charged that the program was based on an outmoded notion that women need an environment protected from men to succeed academically. Yeah. So is that an offensive stereotype?
Yes.
Yeah, that women need an environment protected from men to succeed academically. So case went to Supreme Court, and that's why the court found the policy unconstitutional. Right? Yeah, I have mixed feelings about this ruling, honestly. I get it, right? Government, single-sex schools, unconstitutional. From a constitutional standpoint, I get it. Why do you suppose Hillary Rodham Clinton went to a single-sex institution as an undergraduate?
I don't know.
She obviously felt that it was better academically. Right? And she became candidate for president of the United States. Now, it was private. Not everyone can afford private.
No.
Yeah. And also, I studied education policy.
Yes, you did.
I did. That was my area of expertise, and I'll sum up a lot of research really quickly here. A lot of research suggests, middle school boys may as well, not even go. They're so distracted. Yes. They're so distracted by girls and...
No, it's not us. It's just their own stupidity.
Yeah,
I have watched in my life, the past 2 years, them just flick paper. And it's so enticing to them. I don't understand it. They're so stupid.
Yeah. Anyway, so Mississippi University for Women versus Hogan seemed to settle the matter of state-run single-sex schools, right? But then, dun, there were still some state-run single-sex schools out there. In particular, the Citadel and the Virginia Military Institute, right?
Ooh, military.
Are both in the South.
Yeah.
Yeah, are both there to prepare citizen soldiers.
Yeah.
Yeah, exactly. Do they both have very good academic reputations?
I believe so, yes.
Yes, absolutely. VMI has an outstanding academic reputation, right? So, basically, I'm not going to read this. I'll tell you what happened. So, basically, lawsuit was filed by women who wanted to go to VMI.
Yeah. A lawsuit?
Virginia Military Institute. And case went to the lower courts, right?
Yep.
And they said unconstitutional, right? Based on Mississippi State University for Women versus Hogan, right?
Yep.
Mississippi University for Women. Yeah. So unconstitutional. So Virginia said, fine, we'll set up this Virginia Women's Institute for Leadership. Right?
Yep.
Okay, so do you remember back in the race discrimination cases, how in Sweat versus Painter, the trial judge held up the case so that
for
Texas...
6 months.
Yeah.
So they could throw together some law school.
Exactly. Well, I hate to say it, but that's basically what Virginia did here, right? They said, okay, well, we'll put together a comparable opportunity for women, this Virginia Women's Institute for Leadership. What do you think the funding, facilities, and educational programs at VWIL were like compared to the resources at VMI?
Crappy. They slapped it together overnight.
Yeah. It's VMI is unique. In Ruth Bader Ginsburg's own words, as we'll see in a minute, right?
Yep.
What does unique mean?
One of a kind.
One of a kind. It can't be duplicated. Right? So it bumped around in the lower courts, eventually made it to the Supreme Court, and the Supreme Court said this arrangement is unconstitutional. Quite frankly, just like it was in Sweat versus Painter.
Yep.
Right? So they said this arrangement is unconstitutional. Ruth Bader Ginsburg wrote the majority opinion, which must have been particularly satisfying because she'd argued all those cases before the court earlier, right? And now she was on the court, and she's like, I'm going to write this opinion exactly how I want it, right? Yeah. And so she basically said, this arrangement is unconstitutional. Virginia has provided a unique, outstanding educational opportunity for its sons, but not its daughters. Yeah, great words. Yeah. And so she said, their VMI is going to have to admit students. Yeah. Now, one of the concerns with this was VMI said, if you make us admit female students, then VMI will no longer be VMI.
Yeah.
Because
you're taking away the lifeblood of what it is.
Well,
it will no longer be the same. How could you do this? You're attacking us.
Yeah, basically that's what they said. And there was some merit to their argument because it was a unique educational approach, right? It dealt with the adversative, however you want to pronounce it, it's not a word that's used a lot. It built on the adversative model of education, right? Where there's almost a total lack of privacy. Everyone showers together, sleeps together, eats together. They're yelled at a lot. Strict discipline. It's amazingly Spartan.
Sparta.
Yeah, well, yeah, Spartan. Yeah, not Spartacus. But anyway, and And they said if we have to admit women, then that's logistically going to be next to impossible for us to remain VMI, maintain our identity.
Yeah.
Ruth Bader Ginsburg said, too bad. Are some changes going to have to be made? Yes. But that's what's going to have to happen in order for you to abide by the Equal Protection Clause of the Constitution. Right?
Mm-hmm.
Now, on a practical note, how many women have wanted to go to VMI since this case was decided?
Not very many.
Yeah, not many really honestly want to be yelled at all day, and I don't
I
blame
would
them.
want
I'm
to.
amazed they find guys to go there.
Yeah, well,
Anyway, also on a brief technical note, Scalia dissented.
my man Scalia.
Yeah, your man Scalia, exactly, and he was upset.
Scalia's upset about something?
Yeah,
What?
yeah, shocking. He wrote a scathing dissent, and the only type he writes. And he said, this institution has served Virginia well for decades, and now with our ruling, we destroy it.
Yeah.
Well done. So he was pretty upset about that. The other thing he said is, it's he kind of got a little political. It's liberals that are upset by single-sex military institutions like this, right?
Yeah.
And he said, whatever happened to educational diversity? Virginia offers a number of different educational institutions in its state. A number of them, which are excellent, by the way. University of Virginia is outstanding.
Mm-hmm.
VMI's outstanding. There are just a number of outstanding state schools in Virginia. And so he said, well, what about educational diversity? And basically, Ruth Bader Ginsburg addressed that in her majority opinion. And she said, when the state gives us an interest, like educational diversity, it must be genuine.
Yeah.
Right? Not invented post hoc in response to litigation. Right? So the state interest must be genuine, not invented post hoc in response to litigation. So, in other words, back when VMI was first founded, decades and decades ago, do you think a bunch of men sat around a table going, what we need is educational diversity in this state? No. And so she says, give me a break. So the justification must be genuine, not hypothesized or invented post hoc in response to litigation. She also added a new little wrinkle.
In time?
Yeah, a little wrinkle. She said the proffered justification for deferential treatment based on gender must be exceedingly persuasive. See, Rehnquist didn't really like that they added that new term. He's like, it's all we're doing is making things more complex, right? And she said the burden of justification is demanding and rests entirely on the state. So if the state can't provide an exceedingly persuasive justification for how its policy is substantially related to an important government objective, then what will the court do? Uphold the law or strike it down? Strike it down. That's got to go through all those. So, if there's a law that distinguishes between men and women, it will be classifications based on sex, court will apply intermediate or heightened scrutiny. It will ask, is the policy substantially related to an important government objective? And the burden is entirely on the government to prove that the policy is substantially related to an important government objective, and it must provide an exceedingly persuasive justification for the policy. Make sense?
Makes sense.
All right, so that's where we are after U.S. versus Virginia. So, take care, class, and we will see you next video. Bye-bye.